Hi, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming. Today I'm going to answer a question that comes across my desk all the time as an estate planner, and that is, how do I use a trust to avoid probate? Well, first of all, let's get some terminology out of the way. What is probate? Well, probate is the process that a will goes through after somebody passes away to sort of make sure that the will is valid under Texas law, and then based off the validity of that will, it sort of says who gets what, and then the executor of that will goes and divvies up all the assets and pays off the bills. Well, a lot of people are interested in avoiding probate because probate requires attorneys. It is legal expense, hassle, delay, and a lot of people say, you know what? I don't want that for my family. I don't want my family to have to go through that will probate process after I'm gone. I'd rather avoid that. And so trusts in Texas have become much more popular in recent years. You know, in other states, probate avoidance using a trust has been very commonplace, especially we have a lot of clients who have moved from California, and they almost all have had trusts because they really wanted to avoid probate in California. Well, in Texas, avoiding probate hasn't historically been that big of a deal for clients, but now it is. People more and more so want to avoid probate, and they're interested in using a trust to avoid that will probate after they pass away. So I want to talk to you a little bit about what it would take to use a trust to avoid probate. And really that comes in two steps. It really is that simple. Step one is to have a trust agreement prepared. And usually this would be done with an estate planning attorney. I suppose that you could DIY it. In fact, there's some Texas law that seems to indicate that a trust doesn't even need a written trust agreement. But I am not suggesting that you skip using an estate planning attorney to prepare a trust agreement for you. I think it would be a better idea for you to get an estate planning attorney to help you create that trust agreement. And by the way, that's really easy. When you want to set up a trust agreement with an attorney, it's typically just an intake meeting and then a review and signing meeting. And at that intake meeting, you really just sort of come in as a blank slate and tell the attorney, you know, here's who I have in terms of family, here's who I want to get what I have, here's how I want them to and get it. You know, maybe when I pass away, I don't want them to get a lump sum, maybe I want them to be paid out over time. Whatever. Just come in as a blank slate. Don't go to Dr. Google beforehand and feel like you have to have all the answers before you meet with the attorney. Just come in, meet with your lawyer, and they'll ask all the questions. And from that intake meeting, they will put together a trust agreement, and then you'll meet with that attorney to make sure that the trust agreement does what you want it to do. So step one is you've got this trust agreement created. Now, step two is making sure that you actually have assets going into the trust. So there's sort of this thought out there that, you know, once you create that trust agreement, that all of your assets sort of get sucked in to that trust. And actually, that's not true. Once you create that trust agreement, you have a little bit of extra work to do because you need to put things into your trust. And in legalese, we call putting stuff into your trust funding the trust. So step one is to create the trust agreement, but step two is just as important. That's to fund the trust with your assets. Now, I know that sounds complicated. I promise you it's not. All we're doing is having your attorney prepare a deed for your home to kick that into the trust. And then usually beyond that, it's either just a conversation with your financial institution to make the trust the owner or to make the trust the beneficiary on your accounts. And usually people are pleasantly surprised at how easy it is to get those financial institution documents updated. So it's not really that big of a task. If it feels overwhelming to you, I'm sure your attorney will be willing to help you with it. It's not super expensive. It's relatively easy work for a law office to do. But it's an important thing to do. So if you've done both step one and step two, basically what that means is when you pass away, since you created the trust and you put all your assets into the trust, when you pass away, there wasn't anything in your name when you died. And because there wasn't anything in your name, there aren't any assets to go through probate. So if you do it right and you have an attorney create a trust for you and all of your assets are pointed into that trust, when you pass away, there's nothing in your name, there's no need to probate. There's no asset in your name that we need to have removed from your name because everything just was handled automatically through your trust document. So it's really cool, and I understand why it's becoming so popular because people do want to avoid that probate process. I know the last thing that grieving family members want to have to deal with is attorneys and judges and legal fees and hassle, delays. And so by having the trust and just sort of automating all of those things, I get why it's popular. So I hope you found this video helpful. Again, my name is Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.